Yeah, for a brief introduction, I am a senior partner in IP markets with about 25 years experience as a litigating lawyer, trial work as well as appellate work. And, at IP markets, we deal with a lot of infringement areas, and we have divided ourselves in three divisions. One is litigation, another is registrations and following it up with various registries, and third is the valuation. We are a 100% IP firm, and we don't take anything else apart from IP matters. Anything related to IP matters, even under Section 22 of the Companies Act with the Registrar of Companies, yes, we are willing to do that. Now, I'll straight away go to since there's a constraint in the, yes. Now, in India, the dispute resolution model is before the Registrar of Trademarks, Controller of Patents, Registrar of Copyrights, Controller of Designs, and Registrar of GI, and the IPAB at a certain level. Then subsequent to this, it will be before the High Courts and the City Civil Court. Now, most of the infringement, I will not be going through the slides as such, but I'll be explaining to you what exactly, how we handle the infringements. Initially, under the Trademarks and the Copyrights Act, or for that matter, Patents Act, under Section 134 and 135 of Trademarks Act, infringement under copyrights, or 104 of the Patents Act, in Andhra Pradesh, we appear before the district court because the original jurisdiction lies before the district court. And it's as usual, you ask for the regular injunction orders, and there was an occasion recently in our state where for one movie under the Copyrights Act, John Doe order was given, order against third parties, unknown third parties. So what I'm trying to tell you is that the judiciary is trying to get accustomed to these sort of orders, Mariva orders, Anton Pillar, or John Doe. And there have been issues where such orders have been given. Now, with regard to the dispute resolution models, which is before the IPAB under the rectification provisions of Section 57 and appeals with the registrar under Section 91. Before the IP authorities, generally under trademarks, it starts with Section 9 and 11, where there's an initial objection. Then after the grant and publication of the mark, after the 4-month period has expired, it's the opposition that is if you face the opposition, that's the opposition that you face. And in between the oppositions, you also have a chance to file what is called as interlocutory petitions. I was actually surprised the other day. I was actually even discussing with Sir that if we had taken time enough to go through the Act, the schedule does not prescribe the fee for an interlocutory application, whereas the trademark registry charges you for that, and you file an interlocutory application seeking for adding of evidence, seeking for disposal of the material, or even handling the prima facie case, whether the maintainability of the application is, when it's questioned. Even, the interlocutory petitions can be filed. Apart from that, we have review of decisions under Section 127 of Trademarks Act. The other area where the registrars deal with is 107 of the Trademarks Act, where we have had a lot of matters, and we have filed 107, where someone uses the symbol R without getting a registry. So you go to the registrar and file under 107, but most of the time what happens is it's more of an arbitration which the registrar does, because the provision itself says he has to take it into cognizance, and then the further steps have to follow. As a matter of statistics, we have filed almost about 15 to 20 applications before the registry in Chennai, but only one was taken up. Even there, the other side was called, and then we were said, why don't you settle it? See, these are the, difficulties that we face, and when the reason was sought for, it was said we are already burdened with various other cases in the registry, so we don't want to proceed with this sort of filing of complaints, though there is a provision of law. Then the dispute resolution model under the civil litigation is before the district court, then with the high court, then later with the Supreme Court. Now, though I have restricted the presentation to trademarks, I would like to discuss certain issues that I faced recently in one particular matter with regard to the patent infringement, where for one of my clients I had filed a patent infringement under 104, a counterclaim was filed for that, and the matter was transferred to High Court in accordance with the provisions of 104. Now, what happened in the High Court is there was the counterclaim, and the defendants had also filed a rectification before the IPAB. The question arose as to which has to be dealt with first, the rectification or the counterclaim. My argument before the High Court was, since the High Court is a higher authority than the IPAB, the rectification proceedings has to be stayed in the IPAB, and the counterclaim has to be taken up. But many of you know that there is a matter pending before the Supreme Court, and this issue is in list before the Supreme Court, and Supreme Court is yet to decide whether the rectification proceeding can proceed along with the counterclaim, or both are independent proceedings. Now, taking a similar provision under Trademarks Act, which is 124, where you can seek for stay of the suit, there the law is very clear. It has divided the whole procedure into two parts. That is, first you file the rectification and then the suit, what is the result? Or you file the suit first and later the rectification, what is the result? So in the second case, there is the permission has to be sought, and the civil court itself is accorded the ability to find out if the suit has to be stayed because of invalidity of the mark. So in one such matter where I am appearing, I had sought for the opponent had sought for stay of the proceedings, and I was able to churn out some decisions which says that unless a 3-month period which is prescribed there is complied with, and as well as the court is convinced that it's a matter to be stayed, the proceedings can go. Even others, 124 only talks of infringement, so insofar as passing off is concerned, it can still go on, and interim applications can still be heard, and orders can be passed or reserved. With regard to the (134) and 135, there is a general presumption with the civil courts, not the high courts, the civil courts, that civil courts can get into invalidity of a mark. But if we go through the provisions of 134 and 135, 134 clearly speaks of what jurisdiction is, and 135 clearly speaks of what sort of an order the civil court has to give. The civil court can only give an order, be it Mariva order, Anton Pillar, or John Doe, whatever is the order, along with appointment of commissioner under Order 26, the relevant rules, or an injunction under Order 39, Rule 1 and 2. And the other aspect that would automatically follow is non-following of the orders. Then Order 39, Rule 2A comes in. But we have had various issues where in Order 26, we have had issues where the courts have opined that Order 26 actually amounts to collection of evidence. This happened in one patent matter where I was able to submit a report by an investigation agency, and then I didn't press the infringement application. I sought for the appointment of the commissioner saying, I have enough information and I would like to put forth that information before this court, and then enable the court to arrive at a decision that investigation, appointment of commissioner is necessary, and that based on the report of the commissioner, an injunction could follow. But that application was not entertained, and it was dismissed on the ground that I was seeking to collect or fish for evidence before I go to the, before I seek for the injunction remedy. The other way of seeking for removal of a name or rectification is Section 22 of the Companies Act. There was an occasion where I had filed Section 22 before the regional director and sought that a name for the company which is resembling a registered mark cannot be given. And incidentally, the registrar, the regional director of Companies Act, who's now there is an office in Hyderabad, previously it was in Chennai, did give an order saying, yes, you cannot give a name that is already registered. That is one more method of settling a dispute. Quite recently, we had been having problems with two different authorities entertaining similar names in the same class. That is, let me give you an example, media. Now, I have one of my clients who had launched a particular book, a very well-known book, a monthly magazine and a weekly magazine in the state of Andhra Pradesh, which is read by many Telugu-speaking people. Now, a channel with the same name was launched, and that was causing confusion. Now, when we approached the MIB simply told us, look, we have the powers to grant the license, but unlike the registrar of companies or the person in Chennai, we cannot give an order saying that such a channel cannot be granted. Now, these are all the practical problems we face. So what happens is there are two parallel proceedings which are pending, one before the civil court, one before the authority who has granted. That is mainly because of there is no consonance between two different laws, and that gives a leeway for many applications to be filed, which leads to multiplicity of proceedings before various authorities. The Indian courts, yes, factors for grant of an injunction is the same. Most of you know that balance of convenience, prima facie case, and irreparable loss. But quite recently, the issue of irreparable loss was actually not considered. And the courts have said it's enough if a prima facie case is portrayed by the plaintiff, an injunction would follow, as well as the three principles of the triple identity test, which is mark is identical, goods are of these goods and services are identical, and class and customers are the same. Now, based on this, injunctions are being granted, but the difficulty we face most of the time is the IP literacy of the lower courts, which becomes difficult for us to explain how IP is important and why we approach the courts. Because once an infringement happens, the intrinsic value of loss is something which cannot be computed. Even your accounts of profits which you seek for at the end of the suit may not completely grant you the solace that, it's unfathomable insofar as money is concerned. Because apart from the opportunities being lost and the various, actual infringements that have happened, it's a very small solace that we get. And the other issue which I wanted to share, the last issue which I wanted to share was I was successful in getting a suit filed where both the defendants and the plaintiff are not from Hyderabad, or rather not from a particular place. But the suit was filed in Hyderabad, and I was able to get through the suit on the ground that 134 and 135 are non-obstinate clause, and section 20 of the CPC, which deals with jurisdiction, may not hold too much of water, because 134 and 135 is very clear with regard to where the suit has to be filed. I know it's a very surprising fact that both the parties don't belong to a particular area, but the suit is filed in a third-party place, and then we were able to get an injunction order. So these are the various issues which I wanted to share. Most of these issues are on my practical experience, and these issues have to be dealt with at some stage. But this is, the IP, state of IP is still improving, especially in, it's a better place to practice in Delhi and Chennai. That was what I was told by Praveen. But otherwise, in other district courts, yes, we still have the difficulty. And knowledge in IP or IP literacy is something which we need to get over. Thank you.